Anyone with a question on anything? We discussed wills in the last class. We talked about wills in the last class or generally tested succession. Okay, so in terms of tested succession, we've been able to see the first thing is the applicability of the Law of Succession Act versus the customary law. Okay. Number two, we've been able to discuss the features of a will. We've discussed the advantages or the relevance of a will, why somebody should make a will. We have talked about the various types of wills. That is both the written and the oral wills. We went and talked about making of a valid will. So in terms of making of a valid will, we were able to discuss the question of capacity. Okay, we discussed capacity. Apart from capacity, we discussed the formality, the formal requirements of a will. That is a formality in the making of wills. And then apart from formality, we were able to discuss the question around vitiating factors. We were able to discuss the question around vitiating factors. Are we together? Now, after that, we were able to go and talk about the question of the doctrines, the doctrine of gifts within a will. We talked about the doctrine of redemption, the doctrine of election, the doctrine of lapse, presumption of satisfaction, variation. We talk about the doctrine of variation, and also we talked about the doctrine of disclaimer. And we said that it is your part to know the doctrines and identify them in the question. They will be in the question, of course. So it is you to know. And then in the last class, we talked about the provision for dependence, provision for dependence. Are we together? Provision for dependence. So in terms of provision for dependence, we did say that at any time, and most of the time, you will see somebody coming to you and they're telling you that they have been left out of the will. They have been left out of the will. There's nothing that is given to them from the estate of the deceased person. Okay, it is either during the will or during intestacy. Okay, they have been left out, and in most instances, they will be asking you a question whether they can inherit from the estate of the deceased person, whether they can inherit from the estate of the deceased person. That is normally the kind of questions you will be getting. Now, before you proceed and advise them whether they can inherit or not, then the first thing you need to identify is whether they are dependents. That is under section 29 of the Act. Section 29 of the Act. Now, in discussing that section, remember that we say that it is upon you to understand that section 29 was not amended in any way. Some of you think, or some of you believe, that section 29 was amended. Section 29 was never amended by anything. Okay? The same people that were in section 29 are the same people that are still in section 29. What was changed in section 29, guys, whatever was changed under section 29 was the provision relating to 29C, that is 29(1)(c), on the position of a widower. The position of a widower. That is the only thing that the court declared unconstitutional. Now, you need to understand that bit very well. And I want to project my screen so that I can show you whatever I'm talking about. And please, please, please work with me to understand. Work with me to understand. I know you've had different positions from your classes. Your lecturers have told you that, oh, this can happen, this can't happen. You know, drop all that. Drop all that. Now, this is the law as it is. Okay. Section 29 of the Law of Succession Act. Okay. Now, a dependent is any person that was depending on the deceased person, and therefore, by virtue of being a dependent, they might be able to inherit from the estate of the deceased person. Guys, are we together? Now, that person is defined under Section 29. Now, this act was always like this. This act was always like this, even before the Law of Succession Amendment Act of 2021. Okay, so that Amendment Act of 2021 did not do anything on this section apart from what I've highlighted in green. The only thing that was amended or was really declared unconstitutional through the court case is Section 29C. Now, what is the thing about 29C? What is the thing about 29C? Are we together? Now, 29C provides, as you can see on the screen, that where the deceased person was a woman, the husband of the deceased person will be able to inherit from the estate of the deceased person if he was being maintained by her immediately prior to the death of her death. Okay, if he was being maintained by her immediately prior to the date of the death of the deceased person. Okay, and that therefore meant that for men, you'd have to show maintenance. But for the wives or the spouses who are female, you don't have to show maintenance because 1A says, okay, 1A says that the wife or wives, former wife or former wives, and the children of the deceased person, whether or not were being maintained by the deceased person immediately prior to his death. Now, because of that reason, the widower, the men that were being maintained by the deceased person, they have to show maintenance. Okay. Now the High Court said no. The High Court said that is discriminatory, and that is unconstitutional. And therefore, if you are the widower, you are allowed to proceed and claim inheritance from your late wife, from your late wife's estate. You are allowed to do that. Are you together? So that is the position that was changed under Section 29. And the reason is very simple. This act was enacted in 1981. In 1981, there were certain presumptions that were made, even in law. The first one, it was believed that women don't own properties. It was believed that women don't own properties. Okay, that everything was owned by men. Number two, it was believed that it is women that will remain. Men will die first, and then women will die later. That was the presumption when this act was enacted. And because of that reason, the law even didn't believe that there were some men that were being taken care of by their wives. And that is why it was said under C, they will have to show maintenance, because even the law refuses to believe that there's such a thing. But times have changed. Times have changed. Nowadays, women own properties. Women do things the same as men. And therefore, if you are married to that woman that is, the provider, quote unquote, you are able to proceed to court and have your share from that estate without having to show maintenance. So a lot of things have been changed in the act because this is a 1981 act, and a lot of things have changed since 1981. Are you together? So that was Section 29. That was Section 29. Any question on that? All right, there's no question. Muzame Eugenton, are you there? Muzame using Eugenton. Eugington Muzami. Are you there? I can see you there. Are you there? All right. I don't know why you're in this class in the first place. You know you're not supposed to be here. So I'm going to do you the honors of letting you go. So disappear before I disappear you. Muzame Eugington. All right. So guys, that is section 29, and I hope you get to understand what 29 is about. All right, are we together, guys?
Yes.
This Eugington has a lot of audacity. Serious audacity. Muzami. All right, so as we exit Muzami, let us discuss other things. Now that was 29. That was 29 of the Law of Succession Act in terms of who dependents are. So the first thing you need to ask somebody if they are claiming that they are beneficiaries to the to that estate is the question of, are they dependents? Ask them whether they are dependents. Okay, because it is only dependents that are supposed to inherit from the estate of the deceased person. Only the dependents are supposed to inherit from the estate of the deceased person. Are you together? So that is clear. The next thing that you need to ask them after being dependent is the consideration under section 30. Okay, the consideration under section 30. Now, as you can see from section 30, is that no application under this part shall be brought after the grant of representation in respect of the estate of the deceased person to which the application has been confirmed as provided by, to which the application refers as being confirmed as provided for under section 71. So you cannot make an application for reasonable provision under section 26 if the grant has already been confirmed. We talked about that in the last class. So there must be dependents, and then at the time they are coming, the grant must not have been confirmed. So if that is ticked, then you advise them to make an application under section 26 where they are asking the court for a reasonable provision. Okay, guys, there is no, I want you to understand that there is no application that is made. Okay, there is no application that is made under section 29. People from class B, please, if you're coming from class B, you need to leave the confusion out of the door before you get to the house. Leave that confusion outside. Okay, there is no application that is made under section 29. Okay, you have been told before that if you've been given something, you make an application under 26. If you've been left out, you make an application under 29. That is crazy. That is not the position. There is no application that is being made under section 29 because when you look at section 26, look at 29 first. There is nowhere that says you make an application. There is nowhere that says you make an application under 29. There's not even a mention of the word application. Okay, the only time an application has been made under part 3 is under section 26. And what does it say? That where a person dies after the commencement of this act, and so far as the succession of his property is governed by the provisions of this act, then on the application by, this is the thing, on the application by or on behalf of a dependent. So that dependent must make an application under section 26, and that dependent is defined under section 29. 29, 26, 27, 28, 29, and 30 are all provisions under part 3. Okay, under part 3. So guys, let that not be a confusion point. So is there any question in terms of provision for dependents? Is there any question that you have in terms of provision for dependents? Any question? No question. All right. Now, guys, is it clear? Because some of you will say no question, but then they end up confusing themselves. Okay. Okay. I'm just speaking, to myself. Guys.
So very clear, William.
All right, so let us go and talk about the properties excluded from the will. Properties excluded from the will. Properties excluded from the will. That is what I want us to go and discuss. Properties that are excluded from the will. There are three categories of properties that are excluded from the will. There are properties that are excluded from the will. It means you cannot include them in the will. You cannot make a will and bequeath the properties. You cannot make a will and bequeath these specific types of properties. You can't. Right together, you can't make a will and bequeath these specific properties. So the first one is the question to do with survivorship, okay, or joint ownership. Okay, that is the first one. The second one is a question to do with. Somebody is having the microphone on, please. Zima, mute your microphone. Just look at your phone and check if it is on, or your laptop. Check if it is on or not. Okay, mute your microphone. Nicholas Muriki. You want me to call your name? Zima. Okay, so the first one is survivorship. That deals with joint properties. That is when the part of the property or part of the estate is jointly owned. The next one is donatio. That is gifts in contemplation of death, and then nomination. Right, together. Nomination is the instance where we are saying you nominate somebody. So I want us to discuss them quickly, and then we can move and talk about something else. Now, guys, you need to understand that anytime somebody has died, anytime someone has died, okay, anytime somebody has died, then you can only distribute the net estate. You can only distribute the net estate. What do I mean? It means that whenever you're going to decide what part of the estate you want to distribute, then it must be the net estate. It is only the net estate that can be distributed. So what is the net estate? Okay, what is the net estate? The net estate is the estate minus the liabilities, all the assets minus liability. That will give you the net estate. Okay, so you can only distribute what is his, what forms part of his estate. That is exactly what I'm saying. Okay, what doesn't form part of his estate cannot be distributed. So you only distribute what forms part of that estate. What is going to form part of his estate? That is the only thing that you can distribute. Okay, so there are certain properties that don't form part of the estate of the deceased person. There are some properties that will not form part of the deceased person's estate. Okay, some properties will not form part of the deceased person's estate, and therefore you cannot distribute them either through the will or even through intestacy. They are excluded. You can't have them. Are we together, guys? All right. So the first one are properties that are covered under the question of survivorship. The first one are properties that are covered under survivorship. Okay. What is survivorship? Somebody tell me. What is survivorship? Eric Owino.
I think survivorship can be explained as when one of the joint owners die, then the property will pass to the surviving owner.
All right. So it happens as a result of joint ownership. It comes from joint ownership. So the property must be jointly owned. Okay. Now you guys need to understand the difference between joint ownership and ownership in common. Okay. Now ownership in common, each and every person has got their share. Okay. Each person has their share, and you can be able to identify and pick out the share of a specific person. That is ownership in common. So if it is a piece of land, if you already know that person X owns this, person Y owns this, person Z owns this, that is ownership in common. However, when it comes to joint ownership, then you are not able to identify what each person owns. Are you together? You are not able to identify what each person owns. Are you together? That is what we are saying. That is what I am saying, and that is what you need to understand also as well. That is what you need to understand also as well. Are we together? All right. Now, how do you deal with the jointly owned properties? How do you deal with them? How do you deal with them? So the joint owner, the jointly owned property will move or will transmit to the surviving joint owner. Okay, so there are certain properties that are deemed to be de facto jointly owned. They are owned by virtue of the law. They are deemed to be jointly owned. And one such example is the matrimonial home. Matrimonial home. Okay, so the matrimonial home is a place where you are having your family and your children, and you're staying there with your family. If you're staying there with your family, then that is a matrimonial home. So a matrimonial home is a jointly owned property, and therefore, if one person dies, if one spouse dies, then the property shall go to the surviving spouse. The property shall go to the surviving spouse. So matrimonial homes, and I'm not saying matrimonial property, I'm saying a matrimonial home. Are you together? I am saying a matrimonial home. So it must be a home. Okay? It must be a home, not a matrimonial property. In terms of what becomes a matrimonial property, that will be a subject of the Matrimonial Properties Act, and that is only invoked during divorce. Only divorce will bring the question of what is a matrimonial property. Guys, so that is joint ownership. So when one person dies, then it goes to the remaining or the surviving joint owner. Number two is the question of what if they die in a situation where you can't tell who died first and who died next. What if you're not able to identify or distinguish who died first and who died last? Are you together? Now, in that instance, we need to presume survivorship. We need to presume who died first and who died last. Are you guys together? All right. Now, that presumption of survivorship is what we are calling as the doctrine of comorientes. The comorientes. Okay? Comorientes. Now, what is comorientes? Comorientes is an instance where, yes, Paul?
Wait, sorry, how do you spell comorientes?
Sorry, somebody type comorientes in the chat. Just the way I'm saying it. This the same way I'm saying it. That is how you spell comorientes. The same way I'm saying it.
Okay, all right, okay.
Comorientes, COMORIENTS. Somebody type it in the chat, please. All right. Yes. So that is the doctrine of comorientes, the doctrine of comorientes. So I've said comorientes arises in the instance where one person, or two people, they die in an instance where we can't tell who died first and who died last, who died first and who died last. Now, in that instance, it will be a question of presumption of survivorship. So we presume who died first and who died last. Are we together? Now, in that instance, we are going to assume that the person that died first, okay, the person that died first was the older person. Okay, so if one person was aged 30 years, another one was aged 19, then we assume that the person that died first was the 30-year-old, and the person that died last was the 19-year-old. Okay, so that is presumption of survivorship. So that means, therefore, if you are told in a question that two people, James and John, were in a car and they owned a piece of land and they were involved in a road accident and we can't tell who died first, and then you are told to discuss how the estate is going to be dealt with, how the property is going to be dealt with, then you know that if Peter was the eldest, then the property shall go to the estate of the youngest. That is the question of comorientes. So that is survivorship and the presumption of survivorship. The third thing about survivorship is that if these two people that died together are wife and husband, or if they're spouses, then we shall assume that they died simultaneously. They all died at the same time, and therefore their property will go to their joint beneficiaries. Okay, joint beneficiary simply means that if they have beneficiaries that are joint, for instance, the children that they all gave birth to, or the children that they both adopted, those are their joint beneficiaries. Are you together? So it goes to the joint beneficiaries. So if you have somebody that has a child with someone else, so if the lady was married with a child, or also the guy had a child out of wedlock, then they can't. Those two categories of children cannot inherit this joint property. It can only go to the joint beneficiaries. Are you together? So joint beneficiaries are kids that they both gave birth to, and the one that they all, or the ones that they adopted or accepted. So if they accepted these kids into their family, again, that they will inherit. All of them will inherit in that category. Okay. Any question? Sure.
Good evening, Mwalimu. You've lost me where you stated that where two people have died together, and now it will be presumed that the elder one is the one who died first. So the property will devolve to the estate of the elder one.
What do you mean? What is survivorship? Tell me what survivorship is.
Survivorship is whereby if a property is jointly owned, if one party dies, the other party will now remain with the property. Will the one to, the property they will own the property.
What do you mean they will own? Who is this they? Can you answer this question like you really want to answer this question? Like, what is survivorship? Tua Joan, what is survivorship?
Survivorship is whereby property is property that is jointly owned by two people, jointly, whereby now you cannot distinguish this portion belongs to this one, this portion belongs to this one. Now, if one of them dies, the surviving party gets the property.
The surviving party that gets the property. Okay.
Yes.
And then we have said that what if they die in a situation that we cannot tell who died first and who died last? What do we do there?
The doctrine of Comorientas will kick in.
Which says?
Which says that the one who died. Now that's where now I'm confused.
You can't get confused. What did I say? What I've just explained it now. So what did we say about Comorientes?
The doctrine of Comorientes is whereby the elder one will be presumed is the one who died first.
Okay. So what is the effect of the elder one dying first?
No, that's where I don't know.
So listen, John. What is if me and you own a property jointly and I die? What happens to that property?
It will remain with the one who survives.
Yes, but what if we die together? It is assuming that I'm the elder one. Okay. What happens if the two of us we die together? We cannot tell who died first. What do we do? In that instance, I'm the elder one. It is assumed that.
It is assumed that the property.
Leave alone the property. We are still talking about death. If we die in a circumstance that does not make it easy, in a circumstance that it is not easy to tell who died first and who died last, you and I am the elder one, you are the younger one. What is the provision of the law there? What happens in that instance? What do we assume?
It will be assumed that the elder one died first.
So the elder one is who in this case?
You.
So what is the effect of assuming that I died first when you relate it to the doctrine of, to the question of survivorship?
It will be presumed that I'm the one now who should have owned the property.
Why?
Because now the doctrine of Comorientes kicks in, and now it will be presumed that you, who was the elder one, died first. And if you died first, and now we presume that I was still alive, I should have remained with the property.
Yeah, so the property will go to the estate of the younger one. That is exactly what I'm saying. So if it is assumed that if the two of them die in a circumstance that you can't tell who died first, if you die in a circumstance that you can't tell who died first, then we shall assume that the younger one died last. So the younger one survived the elder one.
Yes.
Okay. So the property will go to the estate of the younger one.
Okay.
You get the point?
Yeah.
Okay.
Thank you.
All right. Any other question from anyone? All right. So that is the question of survivorship. That is the question of survivorship. So anytime a property is jointly owned, then we assume that if one of them dies, then the person that lived or survived the other will get the property. It is as simple as that. And of course, if it is not clear who died first and who died last, we presume that on the basis of age. So the older you are, the less chances that you will inherit. Okay, so that is the rule when it comes to survivorship. That is the rule when it comes to survivorship. So you have to first identify, is the property jointly owned? If the property is jointly owned, then they cannot put it in the will. And if they put it in the will, you will have to file a protest because you cannot inherit, or sorry, you cannot bequeath a jointly owned property in the will. Right, so that is clear. Now let us talk about something else, which is the question to do with donatio mortis causa. Okay, donatio, that is gift in contemplation of death. Gifts in contemplation of death. Morning, Victor. Your hand is up. Very late in time.
I'm sorry, sir. Good evening.
Yes, good evening.
Yeah. How if it's a situation whereby it's me and my brother? We took over some land, our ancestral land, but however, it had not been partitioned. Then we die in a circumstance whereby me and my I'm older than my brother. Then when we pass through when we get an accident pass, who takes whose share?
What do you mean?
When we go with the doctrine of comurientes, we had the piece of land that we jointly owned as
Is
our
it
brothers.
jointly
But
owned?
yes,
So if it is jointly owned, what have we said about jointly owned?
the
Why
younger
is
ones.
why is subdivision coming in place?
So
Why do you
what
need
happens in such a fact?
I'm asking you, why do you need to subdivide it?
Because I may be having some of my children, my brother may be having the children. So those people who may be there as beneficiaries.
So it is not
What
jointly
happens?
owned.
So what happens
So,
in that circumstance?
so first you need to understand this thing, Victor, that a jointly
Yes.
owned property is not subdivided. The fact that it is jointly owned, it means we can't tell that Victor has this and his brother has this. What we know is that this thing, all of it belongs to Victor and his brother. But the fact that you started talking about my share and his share, then that is not a jointly owned property. The moment you talk about subdivision, it is not a jointly owned. So we have said that ownership in common, that is where we know 10 acres of land, 5 belongs to Victor and 5 belongs to maybe to Saina in that instance. So Victor and Saina are brothers. They have a piece of land somewhere in Karen. Each of them have 5. That is ownership in common. So when you die as Victor and Saina remains, Saina can't take the 10. You will have to subdivide and give your share of 5 to your family, okay, to your kids and your estate. If you die all of you together, we will still subdivide and give each of your estates what belongs to you too. Each estate 5. That is ownership in common. But when it comes to joint ownership, it means we will be asking ourselves, this land is jointly owned by Saina and Victor. So if one of you dies, if you die Victor, God forbid, Saina will take 10 acres. All of it will go to Saina. If Saina dies, then Victor will take 10 of it. But if you both die in a situation like an accident, God forbid, that you die, all of you, and we can't say who died first, then that specific estate shall go to the question. The question we'll be asking is, who is the younger one? Victor is younger, and therefore we will assume that when they were dying, Saina died first because he's the eldest, and then Victor died last. And therefore the property will go to Victor because Victor is assumed that Victor died after Saina. So we assume that the elder one died first and the younger one died first. And therefore the estate, the 10 acres, will go to Victor's estate. So when it comes to joint ownership, there's no question of subdivision. Okay, there's no question of subdivision. We assume that the entire estate is owned by 2 of you and you cannot tell who owns what. We just know that this land ni yenyu, nyinyi wawili, and you own it together. Okay? When it comes to ownership in common, that is where we will know that this land is both owned by Victor and Saina has 6 and Victor has 4. So that is ownership in common. I don't know whether you're getting what I'm trying to say.
Yes, I've understood you, sir. Thank you.
All right. So that is joint ownership. So joint ownership, there's no subdivision. You don't subdivide anything. We just know that this thing belongs to you. Okay. For instance, if it is a phone, we know that you can't subdivide a phone anyway. We just know that this phone belongs to these people. Okay? So if it is ownership in common, we know that maybe you have 30%. So when you sell the phone, you'll take 30% and the other person will take 70%. So by the time you start talking about what belongs to me as a person, then that is not joint ownership. The same way for a matrimonial home where you're staying with your wife, you can't say that, hey, this part of the house is mine, that part of the house is yours. No, you can't do that. So by the virtue that it is a matrimonial home, when one dies, the surviving one will take that property. If you die, then the surviving one will take the property. The surviving one will take the property. And if you die both together, then if it is a matrimonial home, for instance, then you are joint. If you're spouses, then your joint beneficiaries will take the property. So,
Yes, sir.
perfect. All right, so let's talk about donatio mortis causa. Donatio mortis causa. Donatio mortis causa. Let me bring my screen back again. That is under section 34 of the Act. Now, this is about gifts in contemplation of death. Guys, understand this point very clearly. Gift in contemplation of what? Death. So, number one, it must be a gift. It must be given in contemplation of death happening. Okay, let us go to section 31. So there's where we find donatio mortis causa, which is a gift in contemplation of death. Gifts in contemplation of death. Okay, now a gift made in contemplation of death shall be valid, notwithstanding that there has been no complete transfer of legal title, if the first condition, the person making the gift is at the time contemplating the possibility of death, whether or not expecting death as the result of a present illness or present or an imminent danger. And you get the point. So for you to claim ownership of the property that is passing to you as a result of gifts in contemplation of death, then the most important thing is that it must be a gift and it must have been made during the contemplation of death. Now, as a human nature, we contemplate death sometimes. We will contemplate that one day, one time we shall die. That does not apply here. That is not the type of contemplation that we are saying here. Okay? That is not the type of contemplation that we are talking about. Guys, are we together? Now, the one that we're talking about right now is an instance where by the time you're making the gift, you are contemplating that you are going to die very soon. Why are you contemplating it? Not because you're just sitting in your house and you're saying, hey, I'm tired of living. No, you are talking about an instance where there is an imminent danger. Okay? There is an imminent danger. You are in a car that is overspeeding, and you know very well that you will not make it, or you've been kidnapped. Okay, you have been kidnapped, or you are, and of course, this I'm saying this with a lot of caution for everybody that have found themselves in that position. Again, if you are in a mall and the mall is under attack, for instance, and you think that you won't make it out, that is an imminent danger. If you're in a house that has caught fire, that is an imminent danger. Okay, so you must be under that pressure of imminent danger, or you have an illness that you think might take you away. You have an illness that you think will kill you. Okay, so there must be an illness or a danger. So if you make it at a time when there's no illness or danger, that is not a gift in contemplation of death. If you just sit in your house or at a bar with your friends and you just say, oh, by the way, if I die, then everything I have should, or this thing should go to my friend. That is not a gift in contemplation of death. Okay, that is not a gift in contemplation of death, because at that moment you're making it, there is no danger and you're not sick. Okay, so there must be danger or sickness. Are you together? There must be danger or sickness. So that is the first one. Now, guys, everything that is listed under section 31 must be there for the gift to pass. Okay, for there to be a passing of the gift, for there to be a passing of this gift in question, then everything that is listed under section 31 must be present. Okay, so the first one is that there must be danger or an illness. There must be danger or an illness. You should be suffering from an illness or from some form of danger. That is the first one. The second one, that the person gives movable property. It means you can't give an immovable property as a gift in contemplation of death. You can't give land or a building as a gift in contemplation of death. If you are contemplating death, you cannot give, okay? You cannot give an immovable property such as land or such as a building. You can't gift an immovable property. So it must be something that is movable. Must be something that is movable. Okay. Then the next point under C is that there must have been a delivery. Okay, to the intended beneficiary of, number one, possession or the means of possession of the property, of the documents, or other evidence of title. So if it is a car, you must have given this person either the logbook, or you must have given them the key, or you must have told them how to access the car. If it is money, you have given them your details, the bank account details, or you've given them instructions on how to access it. So means of possession or title or access, okay? So it must be a movable property. It must be a movable property. At this time, you must have given them what we are calling means of possession, okay? Either the title, the key, whatever. Are you guys together? So that is a gift in contemplation of death. C, number one, the person that makes the gift, the person making the gift is, or the person makes the gift in a circumstance to show that he intended it to revert to him should he survive the illness or danger. So the gift must be made in a circumstance that makes it clear that this person wanted the property back should he survive the danger or the illness. And what is that? In the instance where you are making the gift, you will be saying that in case I die, the word in case I die, that clearly indicates that sometimes you can escape death. You are under some illness or some danger, but you have escaped it. You can always escape it. So if that is the case, guys, if that is the case that you escape it, then the gift will not pass. So that gift must be made in a manner, in a circumstance that clearly shows that you intended to come back to you. For instance, when you use the word, in case I die, so that means the property can only move, the property can only transmit to this person if you die. If you survive it, they cannot come back and say that, oh, you already gave it to me, whether you're alive or not. No, it's only supposed to pass if you die. Guys, tuko sawa?
Yes.
Yes.
All right.
Yes.
All right. Then E is very important. E is very, very important. Okay. This is where the confusion comes in. E. The person making the gift dies from any cause without having survived the illness or danger. What is the meaning of that? The meaning of that is this, that if you are making the gift, for the gift to pass, you must die. Okay? You must die. How should you die? You must die from the illness or from the danger or from any other cause, so long as you have not survived the danger or the illness. Sijui kama tunaelewana? Tunaelewana?
Kabisa.
Yes.
Okay. So what are we saying? We are saying that you should not have survived the ill. You must die. Yes, we agree. You have to die. But you should die from the sickness or the illness that you had. Okay? The sickness or the illness that you had, or the danger, or any other cause without surviving the danger that you are under. Somebody mute your microphone, please. Somebody? Naomi? All right, sawa. So, I'll give you an example. If somebody had COVID, okay, and they give a gift in contemplation of death, okay? Now, for this gift to pass, this person, there are two options. There are two options of death. This person, first, number one, he must die. If he doesn't die, the gift will not pass. So he must die. So in terms of death, he must die from COVID. Okay, he must die from COVID. Or he can die from anything else, including malaria or anything else, or even an accident. But if he's dying from something else, at the time he's dying, he should not have survived. He should not have survived. Right together, the illness, which is COVID. So if he got better, if he was treated of COVID and he got better and he was discharged from the hospital, and then he walks out and is knocked down by a car, the gift will not pass. Why? Yes, he has died, but he has died from a different cause after surviving the main cause that made him make the gift. However, if he had COVID and he was at the hospital, he was being treated, then he died of choking or heart attack, then the gift will pass. Or he caught some pneumonia and he died before surviving COVID, then the gift will pass. So he must die either from the danger or the illness or from another cause, but in this instance, without surviving the cause the illness or the danger. And then lastly is D, so F, okay? That the intended beneficiary survived the person that made the gift to him. This is also very clear that if you are the one that was given the gift, you should not die, okay? You should not die and leave behind. You should not die and leave behind the person that made the gift to you. So if you die before the person that made the gift, then the gift will fail. So you should not die before the person that made the gift. So the person that made the gift must die before you. If you die before them, then there's no way we can help you. Are you together?
Yes.
Yeah.
Okay.
Yes.
All right. That is okay then. If we are together, that is okay. Any question? Now the last one. The last one is the proviso, which is very important, that provided that no gift in contemplation of death shall be valid if the death is caused by suicide, and the person making the gift may at any time before his death lawfully request the return of his gift. So it means if I make a gift in contemplation of death and before I die, I ask you to return it, I ask you to give it back to me, then that terminates the gift in contemplation of death. That will terminate that gift. So if I request it back, then it terminates the gift. It terminates the gift in contemplation of death. Okay? And then lastly, if you die out of suicide, if this person dies out of suicide, you will not get it. You will not get the property that was given to you. And the reason is very simple. The reason is, it is assumed that because this person gave you something, you're the one that encouraged them to die. You know, you told them life is very hard. You know, you've fought enough. You've done everything you can. And you encourage them to die. We will not arrest you for doing that. We will not arrest you for doing that because we don't have any evidence of you doing that. But the fact that this person has died from suicide, you will not get anything either, because we shall assume that you are the one who encouraged them to do that. So if somebody made a gift in contemplation of death to you, then your everyday job from morning to evening is to ask them whether they've eaten, pray that they don't commit suicide. Ask them very nice things, send them messages, encourage them, sing for them, go and visit them, you know, because if you don't and they die, there's nothing for you. Okay? So you make sure that you encourage them every day. Tell them how great they are so that they don't commit suicide, because if they do commit suicide, you will not get anything from that estate. That is the law. That is how the law works. That is how the law works. So please make sure that you know, so that you don't make the mistake when your client is the beneficiary of a gift in contemplation of death. Any question? That is gifts in contemplation of death. And then lastly is nomination. Nomination is clear that some instances, normally some companies and some organizations, they will require you to nominate someone. They will require you to nominate somebody who will be your next of kin or a beneficiary of whatever you own in that company. So if you have shares in that company, if you have some money, the savings, your pension, and everything else in that company, then you will need to nominate someone who will take the properties or anything else from that company in case you die. Okay? And that is the question of nomination. So as a nominee, you don't need to do much. As a nominee, you will not do much. Okay? You just wait until they die, and then you present the evidence of death, which is the death certificate. And then from the death certificate, you will get what is owed to you from that company. So that is nomination. So if someone was nominated to have the property, then that property cannot pass under the will. It cannot be placed in the will. It cannot pass under the will in all instances or at any instance thereof. Are you together? It cannot pass under the will at any instance. So that is nomination. So survivorships, gifts in contemplation of death, and nomination. Any question? So those are free properties. I mean, they're not free properties. You cannot bequeath them under the will. Okay? Any question?
Yes, so, just practically, the exception number 2, that the person making the gift may at any time before his death lawfully request its return. So is it the same way orally, right? Like, for example, if a person is on the deathbed, diagnosed with something, maybe they are going into surgery, and then they tell that person, like, if I die, if I don't make it the surgery, then you can get my car. And then at the same time, they revert and say, look, I take that back. Yeah, I didn't mean it. Or what do they mean by that, please? Is it in the literal sense that they
It's
can
literal.
just...
If you request it back,
Okay.
for instance, if I give you a key to my car. And then I tell my friend, give me back my key. Because remember, for you to have the car, before I die, I should have given you some. I should have given you some means of possession. I should have given you the key or the logbook, or I should have told you where it is and how to get it. So if I request for the property back, the key back or the logbook back, then you can't have it. Okay, you can't have it.
Yeah,
I don't know.
That's a good good answer.
So it's
especially,
it's a literal meaning, just a literal meaning.
Yeah, because I'm thinking the examiner would use the same words, like, but before they went for surgery, they asked for the key back. So those kind of words. Yeah, okay.
That is exactly what it means. All right. Any other question, Robert?
Yes, Mwalimu, I don't know where I got this information from, because I'm not seeing it in the act, that death must occur within a specified period for the gift to pass. I don't know how true that is.
Hata wewe umesema ujui penye ulitoa hiyo maneno. Hata nashangaa umeitoa wapi. The person must have died. That is the only requirement. They must have died. So when they died, the law doesn't the law doesn't say. What the law says, they must die before surviving the illness. So if it is COVID, they can have COVID for 30 years. Okay? So long as they died without getting healed from that COVID, you will still get the property. So the law doesn't limit the time. Are we together? So that one we have not had. I'm not sure of it. It is not anywhere in the law. Because how?
Okay, thank you. Thank you.
All right, Rachel.
Yes, sorry, I was having a bit of technical issues when you were talking about nomination. Could you please kindly just repeat?
No, I can't repeat unless you have a specific question.
Okay, I will ask, what is nomination then?
You're being very unfair with your question now. Yeah, are you saying you've not had anything about nomination that I've said? Nothing at all?
I left when we finished on donatio motis causa, and when
you didn't leave.
No,
Rachel,
I didn't
leave
sorry.
because
My
I've not
network
added you
started
back.
buffering.
Listen, don't lie to me. You didn't leave because I've not added you back.
Yes, what I meant is my network started buffering. So the next thing I heard about nomination was that the property cannot be placed among the ones that are being like in the will. Or for yeah.
That is no, I can't repeat that, Rachel. You're playing. Somebody type that nomination in the chat. Somebody type it in the chat. What did I say about nomination? That is a whole discussion. That's a whole discussion. Is this one? Murimi. Somebody type it in the chat. Murimi?
My question is, can nomination be revoked by marriage?
What do you mean? Cancel, what do you mean?
I think there's somewhere I read, I can't remember where, that maybe nomination can be revoked by marriage.
You read somewhere?
Yeah, sometime back.
No, it can't. What can be revoked by marriage is a will. Are you sure that's not what you read? It's only a will that can be revoked by marriage. Only a will that can be revoked by marriage. Nomination is simple. Nomination is very simple. If you go to the bank will ask you who is the next of kin. Who is the next of kin? Okay. So until you change it, until you go to the bank and change your next of kin, if you die, we'll just know who your next of kin is from the record that you signed. You give your next of kin until you change it yourself. So you getting married doesn't change the next of kin. Okay. Okay, Murimi. Murimi.
Yes, thank you.
You're saying thank you and you're not asking the question. Or have you asked the question?
Yeah, I am the one who just asked the question.
Ah, all right. Jennifer?
A follow-up to Muremi's question. So, okay, in the event that yes, you had nominated someone else and you do get married, or maybe not even getting married, you do create a will, and in that will you do mention that your bank balances and all should go to someone else. Does that negate the nomination you had made? Can you hear me, Mwalimu?
Sorry, I was speaking and my microphone is muted. What I'm saying is a will cannot revoke nomination. A will cannot, once you create nomination, you can only revoke it yourself before you die. But a will cannot revoke it. Okay? A will can't revoke it because the moment it is there once you pick out a nominee, it means you can't even put that property in a will. It is not available to be placed in the will.
Okay.
You get what I'm saying?
Yes.
So these properties are excluded. They're excluded from the will. They can't be in the will. So once there's a property subject to nomination, once there's a property subject to donation, if you make a gift in contemplation of death now, you can't have that property again in the will. Okay. You can't have it in the will. That is what we're saying. If it is survivorship, you can't have the property under survivorship in the will. They are not free properties. The moment it is nomination, the moment it is donation, the moment it is a gift in contemplation of death, or a jointly owned property, you can't have it in the will and say that this property shall go to no. They are not free properties anymore. So the moment you create nomination, it cannot be in the will. However, you need to understand that also having money in the bank and having a next of kin doesn't mean that next of kin is the nominee. A next of kin is just a contact. Okay, it's just a contact. But there are certain instances where you nominate someone legally and willfully. You nominate someone by indicating that in case you die, this person will take this. For instance, if you're creating an investment account, let's say it's a CDSC account, either for the buying of and selling of bonds, or you a CDSC account for buying shares with a broker. Normally you tell them, who are you picking as your nominee? You'll be saying, I'm picking person X, and then they will be asking you, what percentage are they supposed to take? So you'll be saying they will take 100%. Okay, if you say they will take 5%, then you have to provide other people who will take the remaining 95. Okay, or if you're taking out an insurance, okay, life insurance policies, or really insurance policies in terms of a cover. Okay, when you take out an insurance policy, which of course comes after death, after you've died, then you'll have to indicate who is it supposed to go to, this life insurance policy. Who should the insurance company pay, and how much should they be paid? 100% or just 50? And then you indicate 100%. So in that instance again, you'll have to specifically appoint someone. So once you appoint somebody to take it, making somebody a next of kin doesn't mean they are your nominees. Okay? Making somebody a next of kin doesn't mean they're your nominee. Next of kin is just an emergency contact that if something happens to you, we can't reach you, we will reach them. But when it comes to nomination, there must be clear nomination forms that you've signed indicating that this person shall take my property if I die, including pension. If you are having pension, okay, normally you will indicate with the pension firm or even with the employer that in case something happens to you, this person should take your pension. Tuko sawa?
Sawa.
All right. Any other question? So that is the end of wills, guys. That is the end of wills. Any question on wills? Wills ends there. Wills ends there. Wills will end there. That is the end of wills. Wills and wills. Tested succession ends there. The next discussion we are going to have is intestacy. Now, before intestacy, I want us to have a discussion on the question that is on the screen. We look at a few questions in terms of exam questions, how they are set, so that you see whether you can be able to understand or even answer a question or two. Are we together? Now, I want to read for us. And as somebody is reading, know that probate questions are very long and boring. Very, very long and boring. There are a lot of facts. The whole page, 2 pages, you just find one question covering almost two pages like this one. This one actually goes to 2 full pages. 2 full pages. Actually 3. So one question can go until I can get to cover everything until the 3rd page. So they are very long questions and very boring questions, but you must understand the facts as you go. So as you read, I advise you have a note, a marker, or maybe pencil, so that you are able to underline certain things that are important in the question. Somebody read for us. Who will read for us?
Let me read.
Proceed.
Mr. Wesley, a senior counsel and an astute businessman, owned properties which included large tracts of land and houses in various parts of Kenya. He also owned a house in Bond Street, London, UK, which he frequently used as his holiday home. He had 3 wives and 11 children. At the age of 75 years, he started a relationship with Maggie, a marketing executive he met at a business meeting. The relationship thrived, and 2 years down the line, Maggie conceived. She informed Mr. Wesley, who was so elated, and told her that he would marry her. He then began making plans for the traditional wedding ceremony, but before the same could materialize, he suffered a head injury while playing golf and was rushed to hospital while unconscious. He remained in a coma for 2 weeks, and when he came out of the coma, he could not remember much. His first wife, Rebecca, was in his room when he gained consciousness, but he could not remember her at all. His children would visit, but he could not remember them except for a few lucid moments where he would recall some people. The doctors said it was dementia and that his mental state was not so stable. The doctors indicated he would need surgery to remove a clot in his head. After a month in hospital, his first wife, Rebecca, visited him with her lawyer, Mr. Van Vicker, who was also a senior counsel, and asked him to make a will. He mumbled a few words in annoyance, and Mr. Van Vicker, senior counsel, wrote the following words: I bequeath all my earthly possessions to Rebecca, my first wife, who shall have the discretion to share out my estate with my other dependents. I appoint Rebecca and Van Vicker to be the executors of my will, dated 13th September 2020. Van Vicker and Rebecca signed the document and asked Mr. Wesley to sign, but he was not in his lucid moments and was unable to sign. Maggie gave birth 2 months later, and she visited Mr. Wesley with a newborn baby boy. He was so excited, and the doctors were happy that his excitement triggered his memory, and he even named the newborn baby Wesley Jr. Maggie visited every other day. 3 days before his scheduled surgery, one bright Sunday afternoon, Mr. Wesley asked for his doctor Benjamin and his best friend and confidant, Ashton Jones. He also asked for the nurse on duty, and he told Dr. Benjamin to write down the following: Maggie has given me so much joy in my old age. In case I die, I have given Maggie house number 154, Bond Street, London, as a gift. I shall immediately instruct my London lawyers to effect the transfer immediately. I am proud of my last born son, Wesley Jr., who is just an infant. All my other children are adults. Continue scrolling kindly. To avoid him missing out on my estate, I give and bequeath my 10-acre ranch in Sweet Waters to Wesley Jr., which shall be held in trust for him by my confidant Ashton Jones. The rest of my earthly assets and possessions shall devolve to my 3 wives in equal shares, who shall have a life interest on the same, after which the same shall devolve to their children. I appoint Ashton Jones and Dr. Benjamin as joint executors of my will, dated this 10th day of December 2020. Mr. Wesley appended his signature. Ashton Jones, Dr. Benjamin, Maggie, and nurse on duty all signed the document as witnesses. Mr. Wesley then made a call to his London lawyers and instructed them to effect the transfer of the Bond Street house to Maggie. He further told them that Maggie would contact them directly to give them her details. A week later, Maggie received the transfer deed from London and visited Wesley in hospital so as to get him to sign it. He was not able to sign on her first 2 visits as he was not in a proper state of mind after surgery, but he eventually signed on her 3rd visit and told her the Bond Street property would belong to her if he died. Maggie executed her part and later sent the transfer deed and all documents to the London lawyers. Mr. Wesley, senior counsel, died 2 weeks later after suffering a blood clot in the lungs. After his burial, Ashton Jones called a family gathering and read out the contents of the will dated 10th December 2020. Rebecca was not pleased, as she believed, being the first wife, she was entitled to a larger share. She thus informed the gathering that the deceased had already made an oral will dated 13th September 2020, which came before the will of December. A. In light of the narrative and with the help of case law and relevant statutory provisions, discuss the validity or otherwise of the will dated 13th September 2020 in relation to the will dated 10th December 2020. That one has 8 marks. B.
Oh, you can't read all the questions at once. Let's start with the first one. So thank you so much for that clear and concise. Very good reading. Now, guys, you have the facts with you. We can discuss this question quickly and go to another question if time allows us. So what do you guys think? These questions are very long. So as you read down, you note certain things. So discuss the validity or otherwise. Let's go to the question. Discuss the validity or otherwise of the will dated 13th of September 2020 in relation to the will dated 10th of December 2020. Okay? That is the first 8 marks. So, guys, this is the will that was dated 13th of September, the one I'm projecting now. Do you think this will is valid? So we talked about the validity of wills. So I want you to run it through the requirements of validity. This is the will I'm highlighting as green. And I'm expecting you guys to put up your hand. But you guys are not putting up your hands. Okay, let's start with Michael Okile. So run it through the 3 tests.
So the test that I will put that particular piece of will is, first of all, who is making the will?
That is not a test. First, answer the question in terms of, is the will valid or is the will invalid? And then you go to give us the three issues. You can give us 4 if you want, but of course there are 3. The 3 issues that is going to make you arrive at that answer that it is not valid or it is valid. Number 1.
So I'll say the will is not valid based on the following factors.
So remember, we are starting with the will dated 13th of September 2020. So according to Michael, the will dated 13th of September 2020 is not valid. So why? Give us your first reason.
The first reason is that it does not disclose whether the testator is of sound and disposing mind.
That is not a good answer, my friend. That is not a good answer, my friend. I will look for you and I will deal with you. I have taught this before. I will hunt you down and I will hunt entire estate of yours if you give me a wrong answer. Guys, what did we say? Thank you very much, Michael. Let's go to someone called Ojako Steven. I want you to help Michael. Okay, so do you agree with what you said or not?
Okay, I don't agree with him, but my version is that the will is not valid because it was not signed by the testator first.
So it is not valid because of the signature. So your first reason is that the will wasn't signed by the testator.
Yeah.
Okay.
Then number two, it was not attested. Yeah.
Just the first. Let's start with the first one. So do you think that this will is valid? Your answer is no, it is not valid. Why is it not valid? So the first reason you provided is because it wasn't signed by the testator. Okay, that is what you're thinking. Okay, but remember, these people are claiming that it was an oral will. Now, does it meet the elements of an oral will? Okay.
It doesn't, because it was written down.
No, my friend. I will hunt you also. I will hunt you personally. Guys. Guys, this is an oral will. Is it an oral will first? Because remember, listen, let's go back to the question down there. Down. Now, Rebecca was not pleased as she believed being the first wife, she was entitled to a larger share. Okay, she thus informed the gathering that the deceased person already made an oral will dated 13th of September. So the question is this an oral will dated 13th of September? Okay, does it meet the requirements of an oral will? What is the reason? So when you come back, because the other party is saying, yes, we have an oral will, the other party is saying, no, we don't have an oral will. Okay, is it an oral will? Okay, and does it meet the validity of an oral will? Yes, Tua Joan, we are with you.
I think it meets the requirements of an oral will.
How?
Because
so wait first.
Because
you answer the question. Is it valid? Number one, is it valid? So
it is
everything is come again.
It meets the requirements of an oral will, but it is not valid.
That is two contradicting words. It can't meet the requirement if it is not valid. What do you mean? If it meets the requirement of an oral will, then it means it's a valid oral will. So do we have a valid oral will?
No, we don't.
So start again. What is the answer to the question? First, the validity of the question. The validity of the will. Do we have a valid oral will or not? And if you think it is not, then give us the reason.
We do not have a valid oral will. First, because of the mental capacity of the testator.
Okay. So that is the most important thing first. So first and then second, proceed.
Secondly, because of the attestation.
Which attestation? Proceed. What about attestation?
Because of how it has been executed. First, the testator has not.
The testator
has not signed the will.
But it is an oral will. Must an oral will be signed?
No.
Okili.
Because of the two witnesses. One
What is
is
wrong with the two
Rebecca,
witnesses?
who is his wife, whereby now one of the parties is a beneficiary. The will is supposed to be.
John.
Yes.
John. I will deal with you. What are you saying, my friend? What are you saying? Is that what I taught? Mbona unanipea aibu mbele ya wageni? Is that what I taught in this class? No, I didn't teach that. And you see now, this is a very easy question, guys. You know, when you read probate, you're like, oh, this probate is very easy. Why do people fail probate? This is exactly why people fail probate. Very small things that you forget and then they confuse you. So, no, John, you are on the right path, but you will end up not getting the marks, even though you have an idea, but you can't tell us how. Okay? Saina George, what do you have for us, please?
Thank you, Mwalimu. First of all, my position is that the oral will is not valid.
The oral will dated 13th of November, 13th of September is not valid. So when you introduce your point, just like you said, fine, which is fine, you indicate that the oral will dated 13th of September 2020 is not valid for the following reasons. Number one, okay, you give us the reasons. Number one.
Yes, one. Yes, the oral will was made before the people who are not competent as witness. Is not made before people who are not competent witness.
Who is a competent witness? Mr. Steiner? Who is a competent witness?
Competent witness is a witness who is not going to be a beneficiary of the estate of the deceased.
Mr. Steiner?
And also not related to the deceased.
You're forgetting one thing. You're forgetting the fact that I know even your house. I will come for you there. I know even your house. What are you saying? Guys, you're confusing between competent and independent. Independent witnesses are the ones that are not inheriting anything from the estate. A competent witness is a witness that is above the age of 18 and has sound mind. That is a competent witness. If you're above the age of 18 and you have a sound mind, you're a competent witness. But independent is the one that is not inheriting anything from the will. Now, Mr. Saina, do you want to take it again? Or do you want to give the baton away?
No, I was unmuting my mic.
Okay.
So the oral will is made before people who are not independent and independent people.
My friend.
Because they're going to be the beneficiaries. Then the second point.
Don't even try going to the second one. The first one is not right. The first one is not right. There is no requirement in law that a will should be made before independent witnesses. The fact that you make a will before witnesses that are going to inherit from the will doesn't make the will invalid. Guys, that is also a hint that you need to. I taught this, guys. I taught this thing. Nilifunza hii. Okay? So guys, please. Acheni kunifanya hivyo. So guys, why is this will invalid? You guys are not telling me why. If it is invalid. Alphonse Owino.
Yes, I concur with Mr. Saina that the will is not valid. It is not a valid oral will. And my first reason is just as his. There was no capacity. The testator did not have capacity to bequeath because he was not in his lucid moments. Then the second one will be because in instances where a will is made before a witness, or it is witnessed by a person who is a dependent, then there should be an additional witness to ensure that the witnesses who actually witness who are independent are two. So in addition to Rebecca, who is a dependent in this will, we ought to have had another one so that we have now two independent witnesses.
So is the will
so
valid or not?
Witness, it is not valid. Then the third reason will be because of the time.
Don't go to the will. Don't go to the third one. Come back. What are you saying? What are you saying, my friend? Guys, let me say that again. The rule of witnesses attesting, beneficiaries attesting a will, it only applies to written wills. That rule only applies to written will. And even though it applies to written wills, it does not affect the validity of the will. It only affects the gift. It doesn't affect the will. The fact that there are two witnesses that have attested to the will, which is written, does not make the will invalid. Guys, I will sing this from the top of the mountain. That when you as a witness, when you as a beneficiary attest to a will, it does not affect the validity of the will. The will is still valid. However, you as a witness, you will not get anything from that will because you're not independent, unless you bring other independent people as witnesses. So witnesses attesting to a will, beneficiaries attesting to a will does not affect, does not affect, are you together? It does not affect the validity of the will. It only affects the gift that is given to that specific witness. And remember, that rule does not apply to oral wills. Does not apply to the oral wills. Okay? So guys, any last chance? So Alphonse, you've made the point clear. The first one is that the fact that this will is not a valid oral will. Okay? The will is not a valid oral will for the following reason. The first reason is that this will was made at a time when the testator was not of sound mind. And where do you get that rule? Banks versus Goodfellow, that defines the questions to do with mental capacity. And the question also tells you that this person was not in his lucid moment. He could not sign the will because he was not in the lucid moment. So again, remember that a person that is of unsound mind can make a will, but only during the time when they are in their lucid moments. Are you together? So that is the first reason, mental capacity. Okay? The second reason is now on the question of formality of this oral will, the formality of an oral will, validity of an oral will. What else is making this oral will not to be valid? Guys, what else is making it not to be valid? Omondi Rachel.
Another thing that makes his will not valid is that he made a written will after that was properly signed and attested to.
No. Leave alone that point. Leave alone that point. What else is making this will? What else is making this will invalid? Guys. Nitawatuanga.
Could it be that
guys. All right. Owino, Eric.
Yeah, the other one is that the testator must have died in 3 months.
Within the 3 months?
Yes, the will is dated 13th September, but senior counsel dies, maybe if you go down there, I think he dies after the 3 months. And this,
which is?
If we juxtapose with the section, he dies in I can't see, but from your reading, it was more than he died more than 3 months. So that makes it invalid by the section 9(1)(b) of the Act.
Are you sure? Are you sure about the timeline? This person died on the 10th November 10th. Let me get you the specific date that this person died. All right. So he died on the 28th. He died on the 28th of December, which is 2 weeks after making his will. 2 weeks after making his will. Okay, so September to October, November to December. So anytime after 13th of November of December, that person was died out of time. So again, that is another reason why the will is invalid. Okay, so why is it invalid? Number one, capacity. Number two, the question of validity of oral wills, which is the testator must have died 3 months. 3 months from the date of making the oral will. In this case, this person died way after 3 months, and it is not a privilege. It's not a privilege will. So he died way out of the 3 months. Are you together? So that will was not valid. That will was not valid. And then the third point, which is not an absolute point, is that if anything, that this will was valid, then the second will that was made on the 10th of December actually would have revoked the will dated the 13th of September. So the later will, which is the will that was made in December of the 10th, would have revoked the will that was made earlier on the 13th of September. Are we together? Now that in itself summarizes the validity of the will dated on the 13th. Guys, I've talked about this time and again and again and again. So when it comes to validity of oral wills, we have oral wills and written wills. Oral wills are made orally. So long as they're made orally and they're made before 2 or more witnesses, it doesn't matter whether the witnesses are beneficiaries or not, that will still be valid. Okay. Number 2, oral wills sometimes can also be written down. Oral wills can also be written down. And I've given you the case of Wambui Gikonyo, Rufus Ngefe. In those 2 cases, you remember that the testator made a will, which was oral in Kikuyu, and they were written down in in English, translated in English on a piece of paper. So that was still an oral will. The fact that a will has been said, it has been mumbled orally, and somebody has put it down on paper, doesn't make it a written will. Okay, so the will dated 13th does not meet the test of an oral will, and therefore it is invalid. And if anything, if it was valid, it could have been revoked by the second will. Okay, now let us go to the second will, the will dated the 10th of December. Do you think the will dated the 10th of December 2020 was a valid will? Why do you think so? If it is, put up your hand and tell me, why do you think the will that I'm projecting on my screen? Let me try and reduce this font. Yes, the one that I'm projecting on the screen, do you think it is a valid? Okay. Do you think it is a valid will? And why do you think it is a valid will? If it is valid or if it is invalid? Yes, Rachel, quickly.
I think the will dated the 10th, of December is a valid will because first, it was made when the testator was in his lucid moments, despite the fact that he was suffering from other mental illnesses that could have hindered his capacity. When it was being made, he was in a lucid moment.
So the first one, let's start from capacity. So this person, so you will be saying, you introduce your point and say that the will dated 10th of December 2020 is a valid will for the following reasons. The first reason is, number one, the testator had the capacity to make the will, or you can write capacity and you explain. In terms of capacity, the testator was in the lucid moment, as well as the testator was above the age of 18. And if you want a case to support that, that is Banks versus Goodfellow as well. What is the second reason why this will is valid or invalid?
The will was properly attested to, with the testator affixing his mark in the presence of both the witnesses, and it being attested to by both the witnesses as well.
So it was executed properly. There are 2 points there. There's execution and there's attestation. So it was properly executed by the testator affixing his mark on the will, and then it was properly attested by 2 competent witnesses, being Ashton Jones and Dr. Benjamin. Okay. Is there any other reason why this will is valid or invalid? None. All right. So that is the validity of this will. So the question of validity, the question of capacity, execution, and attestation. Okay. Now, if there was a question to do with a vitiating factor, which is not here, so we don't raise it because it is not here. Mistake, undue influence, and all that, they are not here. So in as far as this will is concerned, then we talk about capacity, the age, and the mental capacity. It was in his lucid moments when he made the will. And of course, he remembered all his beneficiaries, he remembered all his properties. And of course, that is as per Banks versus Goodfellow. And then he properly attested the will. So he executed the will under Section 11 by affixing the mark, and as well as having the will attested by at least two witnesses who are also competent witnesses, okay, and who are not beneficiaries, competent and independent. But of course, independence doesn't make the will invalid or valid. All right, so that is the question there. We will do more questions on validity wills because it looks like we need to do more. Okay, Ashton Jones has decided to petition for grant. He has approached you. Name 2 main pleadings to be filed in court. Ashton is the executor of the will. He has approached you. I know we've not done this, but you can just mention them if you know. Anybody wants to try? What do you think are the main pleadings? Nobody knows? Michael?
I think the pleadings will be in the prescribed form, which is a petition for letters of grant of probate with the will annexed.
That is very well. That is the first one. That is what follows it. So we have petition for letters for grants, petition for grant of probate, of course, with written will annexed because there's a written will. And then, of course, it comes with a Kamunyo.
A supporting affidavit?
Yes, the affidavit in support. Okay. Okay. Now let us go to the third question, which says, the third wife, Marianne, decided to disregard both wills and sought legal help. She has insisted that the deceased person died intestate and his property should be divided equally among his 3 households. It is a case that Maggie should not own the Bond Street land and property, as she was not known in the family, and that she was a gold digger, not worth any asset from the deceased, and that the Bond Street property should revert back to the deceased person's estate. Maggie has approached you for legal advice. With the help of case law and statute provisions, evaluate Maggie's claim as regards the Bond Street property. Evaluate Maggie's claim as regards Bond Street's property. Are you together? Okay. So I want to see points and answers. Mr. Wesley has appended his signature on the will. Ashton Jones, Dr. Benjamin, Maggie, and the nurse on duty all signed as witnesses. Mr. Wesley made a call to his London lawyers and instructed them to effect the transfer of the Bond Street property to Maggie. He further told that Maggie would contact them directly to give them her details. A week later, Maggie received the transfer deed from London and visited Wesley in hospital so as to get him to sign it. He was not able to sign on a first 2 visits as he was not in a proper state of mind after surgery, but eventually signed on this third, okay, and told her the bond street would belong to her if he died, okay. Maggie executed her part. Let me just highlight that to you, as it was not part of, okay. There. So Maggie executed her part and later sent the transfer deed and all documents to the lawyers. Mr. Wesley died 2 weeks later. Now tell me, discuss the state of Bond Street property, London Bond Street property. Someone tell me, guys. These are things we've discussed as late as today. Bond Street property. What is the state of that Bond Street property? Guys, put up your hand.
Digesting.
What are you digesting? Are you eating? I'm waiting for hands, guys. Hands. Wekeni mikono juu. Let us speak to. Let's start from Alphonse.
Yes, my view is that that property will not pass, and the main reason why I'm saying that is because it was a house, and basically for something to pass as a donation or as a gift in contemplation of death, it must be a movable property. Now, this being a house, it was immovable, so it would pass. So that is my view.
All right. Saina George.
Actually, you said what I wanted to say, that the property will not be passed as a gift because it's immovable property. It's a real estate.
Somebody else? Guys, what is the status of this property? Does it go back to the estate? Does it go back to the estate? Yes, Gertrude?
A question, if he's already signed a transfer and the only person who was in the room when he told her that it should only pass if he died, what's the effect of the transfer? He signed the transfer, she signed the transfer, it's been sent back to London to the lawyers.
That is what this entire question is about, the analysis of facts. Everything you're going to discuss here is just facts. Facts of the question. Whatever you're going to write in this statement is just the analysis of the facts. So your point is, Gertrude?
the matter of whether of the donation is invalid since there was already a transfer in place that they had executed. And then he said afterwards, only so it will still pass since there's already the transfer in place that he executed while he had capacity to transfer the property.
All right. Thank you very much. Joan, Tua, you want to add something?
Yes, there was something I was thinking about now because the house is located in London, and I think whether it will devolve into the estate of the deceased person will be determined by the laws of the status of the location of the house.
That is not a question to be identified here. It's not a question of ownership. Ownership has already been dispensed with, so it belongs to Mr. Wesley. So it's not a question of ownership or not ownership. So guys, the question is very simple. This property has already been transferred. This is a gift inter vivo. This is not a gift in contemplation of death. Okay, this is not a gift in contemplation of death, because if you read what forms part of a gift in contemplation of death, is that first it must be something that is movable. This is not a movable property. It is not a movable property. It is not a movable property, because when you go to the facts, let me just read for you the facts. Yes, he's owning a house in Bond Street, London, UK, which is frequently using as a holiday home. So this property will not pass as a gift in contemplation of death because it is, okay, it is an immovable property, which does not form part of a gift a gift in contemplation of death. Number two, you must note the fact that this property, this person has already signed. The transfer has been signed. So the transfer of the property has been done during the lifetime of the deceased person. Okay, you're being told that he signed the transfer documents, and then the property, Maggie signed her part, and the property was sent back to London lawyers for their completion. So that makes the property a gift inter vivo. It was a gift inter vivo that was given to Maggie during the lifetime of Mr. Wesley, and therefore that will not form part of the estate of the deceased person. And therefore, even if the estate was supposed to be divided according to the rules of intestacy, the gift inter vivos do not form part of the estate of the deceased person, since the transfer was done during the lifetime of the deceased person. Okay, so that is the question to do with the gift in contemplation of death. Guys, the examiner sometimes may trick you. Sometimes they deliberately say that, or sometimes they forget. But make sure that you know the rules when it comes to gifts in contemplation of death, which must be a movable property. Sometimes we've seen gifts in contemplation of death which are movable in some instances, but for purposes of being clear with the law, because that's what the law provides, make sure that you know that gifts in contemplation of death are only on movable properties. Okay, so that is the rule, and they don't form part of the estate of the deceased person. So that is the answer to that question. And then D, assume that both wills were nullified and the court has directed for the matter to proceed as if the deceased person died intestate and appointed all the three wives as the administrators. They have refused to consider Wesley Jr., saying that he is an illegitimate child as his mother was not a wife of the deceased person. Briefly discuss whether Wesley Jr. is entitled to a share of the estate of the deceased person. Okay, mikono juu. Do you think Wesley Jr. is a beneficiary to this estate? Okay, are they entitled to the estate? And of course, you introduce your point by first indicating that whether Wesley Jr. he is not entitled to a share of the estate because of the following things, or Wesley Jr. is entitled to the estate of the deceased person because of the following reasons. So you make the first point and then you give the grounds for your answer. Okay, guys, do you think that the child of Maggie, that is Wesley Jr., is entitled to a share of the estate of the deceased? 4 free marks. Guys, you guys don't have your hands up. Guys. Somebody who has not spoken, man. Say something. Let me see someone who has not spoken here. Rahab Mukiama.
In this case, all Maggie needs to do is to prove that Junior is the deceased son, probably through a DNA, and if yes, he is entitled to the estate.
So the child is not. We are not complaining. Nobody's complaining about whether Mr. Wesley is the father. They're saying Mr. Wesley is the father, but Wesley cannot inherit because he was born out of wedlock, since the mother was not a wife of the deceased. So, do you think a child born out of wedlock should inherit from the estate of the deceased person? That is the question. So it's not about whether we should do a paternity. No, paternity is not disputed because they're both agreeing that Wesley Jr. is the son to Mr. Wesley. But the only question is, should he inherit if he was given birth to out of wedlock? That is the question.
All children, whether in-law, outlaw, are
What do you mean
dependents of.
What do you mean in-lock and outlock?
As long as a child is born and it is proved that is the biological son, and in this case there is no dispute, so he is entitled to the estate of his father.
Where do you get that from?
On the dependents. Is it section what of LSA?
My friend,
section what?
You need to confirm and have a legal basis.
Section 29. Section 29 of LSA.
Before we get there, there's something I'm looking for. Somoni.
Yeah.
Somoni Victor, something I'm looking for.
Oh, okay. For me, in my view, Junior is entitled to the estate of Mr. Wesley because this child was born eight months after the death of Mr. Wesley. But under section, yes.
We are not claiming the time. We are not claiming the time of death. We are not claiming that is not the son of Mr. Wesley. All of us are agreeing that is the son of Mr. Wesley. But should he inherit?
Yes, he should.
That is exactly what you need to tell us why he should.
Yes, he should, because the property in abroad was bequeathed to him for under trust by the mom.
My friend, hiyo yako ni kali kabisa. Hapa ongeza chesa. What is? So Mr. Wesley, not Mr. Wesley, that was Victor. Victor, the question is this. You have a child out of wedlock. I'm not saying you have, but if you have a son out of wedlock, Victor, and you die, should that child inherit? Wesley? Not Wesley. Victor? All right, Rebecca, not Rebecca, Wamalwa, please help us.
My opinion is the child should inherit because the child is a dependent to Mr. Wesley, and this is found under section 29A. The child being a biological child to the deceased does not need to show maintenance for him to inherit, whether the deceased was providing for the child prior to his death or not.
All right. All right, guys. What I was looking for is under section both 29 and section 3. That is what I was looking for. Mostly section 3. That the first thing you need to understand is the definition of a child. That section 3 defines a child as any person that is born of the deceased person, provided they're born alive. Okay. It doesn't indicate that they have to be born as a result of a marriage. Okay. So long as they're born of the deceased person and they're born alive. That is what the definition of section 3 is. So long as the child has been born alive and born of the deceased person, they are categorized as children under the Act. And then you go to 29 and indicate that as per section 29 of the Law of Succession Act, that is 29A, children of the deceased person, born of the deceased person, are entitled to inherit from the estate of the deceased person, whether or not they were being maintained by the deceased person. That is the provision of the law, guys. That is the provision of the law. And then you come and give us now the facts of the case, the analysis. So from the question, you will be indicating that Wesley Jr. was born of the deceased person, that is Mr. Wesley. Okay? Or Wesley Jr. is a biological child of the deceased person, Mr. Wesley. And for that reason, he is entitled, as per section 29, as a dependent to inherit from the estate of the deceased person, whether or not the mother was married to the deceased person or not. Are you together? So that is exact. So start with the provision of the law, section 3 and section 29, and then you give us the facts. So always start with the law. What does the law say? For instance, if it is about the question of donatio mortis causa, gift in contemplation of death, what does the law say? Tell us what the law say, and then marry the law and the facts in the question. Or if it is about making of valid wills, you will be saying section 11 provides that a will must always be executed and attested for it to be valid. And then you marry that with the question. From the question provided, the will dated this day was executed and was attested, and it was a valid will. So give us the position of the law first, and then marry the same with the facts. So your main principal provisions would be section 3 of the Law of Succession Act that defines who a child is. That's a child born of the deceased person, provided they're born alive. At the same time, section 29A defines dependents, and it says that dependents of the deceased person, including children, that is 29A, are not supposed to or are not required to show maintenance before they inherit from the estate of their father. They don't have to show maintenance. Are you guys together?
Yes.
All right. So that was all the free marks you could have gotten under question 1. All the 20 free marks. You just need to understand what the question is talking about, the rationale of the question, and where the examiner is coming from, and just a little bit of what the law says about that circumstance. Okay? Don't overthink it out of the box. Just pay attention. Just pay attention. Probate questions are very long, very, very long, the longest. So have a pencil with you as you work in that exam. Read as you underline the main things. Read as you underline the main points and the pointers so that you don't miss them when you discuss. Are you together? All right, questions, please. Stephen Ojako.
I wanted to know how fatal is it to quote the wrong section of the Law of Succession Act when you're
Very
answering the
fatal.
question.
Very fatal. You will not survive it. It is very fatal. Extremely. You are better off simply saying the Law of Succession Act provides this. The Law of Succession Act provides. Okay, the Penal Code provides. Okay, the Constitution provides. Okay, the Civil Procedure Rules provide. That is if you don't know the specific section. But if you know the section, provide the section. But if you quote the wrong section, you will get a wrong. There's no doubt about that. You will get a wrong unless the examiner has missed that one, but they will not miss any point. So just provide the general provisions. But if you know the section, quote the exact. Before you quote a section, just make sure you're quoting the right section. Are you together?
Thank you. Yes, well understood.
Okay. Joan?
Okay, in an instance whereby you have a case law instead of a section of the law, you do as you have told us.
Which is what?
Which is you first indicate what was held in the case, then you apply.
Of course, the case will come from the law, from the section of the law. So just provide the law provides, or in this case, it will say this, okay? So if you know the case that you're talking about, say in this case, the court in the case of, okay? The court in the case of provided the following things, okay? Like Otensai Wanjiku Yawe, for instance, that is a one that deals with the question to do with cohabitation. So just say the court in Otensai Wanjiku Yawe versus the public trustee indicated this, and then you go ahead and give us what is in the fact. If you know the section of the law, again, section this of this provides this. Are we together?
Yes, thank you.
All right. Any other question? Stephen Ojako, your hand is up.
Yes, is it a must that when you are mentioning a case law, you must cite it properly as required, including the year, or you can just mention the
What
name?
are you asking? Are you planning to answer questions wrongly in an exam? First, your first question is, must you quote the correct section? Now you're asking, must you quote a case correctly? What is your plan with this exam?
If I forget the section and also the exact citation of the case law.
You can't quote a wrong citation. If it is Saina versus Abdi, you can't say Abdi versus Noor. You have to give us the correct names, guys, or the bare minimum, you have to give us the name of the case. If you decide to go with a case, at least have the name of the case. If it is Otensai Wanjiku Yawe, you can't say Otensai Ilda, for instance. You have to quote the correct name. If you decide to go with a section of the law, quote the correct section of the law. So you can't, there's no way around it. Nobody's asking you. Nobody is asking you to say that, let's say, Banks versus Goodfellow, 1971, Queen's Bench, ELRC. No, just give us Banks versus Goodfellow. So if you're planning to quote a case, at least have the right citation, which is the name of the case. If you're trying to quote a section of the law, please have a section of the law. Just say section 29 of the Law of Succession Act. If you don't know, just masquerade by saying the Law of Succession Act provides. So long as you're saying the right thing, don't create facts for yourself. People do create facts in case law. Okay, don't create facts for yourself. Just provide whatever is provided for, and that one you will be fine. Are you together?
Okay, thank you.
Okay. All right then. Tianga?
Mine was just curious. I don't know if this would be forcing issues now. The question on the on the land and property. I just wanted to know whether I was on the right track. My train of thought was you talk about the testamentary freedom of Mr. Wesley. And then, of course, you have discussed about the transfer issue. What I'm most curious about is whether, if you were to quote Wingrove versus Wingrove, stating that maybe the love and affection that Maggie gave to Mr. Wesley amounted to passion.
What do you mean love and affection? You don't know what kind of love Maggie gave to Mr. Wesley. That is not told in the question. You are not told that they are giving each other love and affection. We don't know that.
But there is an insinuation that he really liked her. So I don't know. Okay,
the liking doesn't matter. The liking doesn't matter. That is serious forcing issues. The liking doesn't matter. The question on testamentary freedom, is fine. You can always add it, because anytime somebody makes a will, then they make the will on the basis of a testamentary freedom. That one is okay. But on the question of love and affection, Wingrove versus Wingrove, that question relates to undue influence. Wingrove versus Wingrove is a case on undue influence. So you can't start saying that, oh, Mr. Wesley was given love and affection by Maggie, and therefore Wingrove was... No, that is not relevant. That is actual forcing issues. Real serious. Okay, so don't force that issue there. Okay, that issue doesn't apply to you. All right.
Okay, thank you.
Perfect. So guys, I'm feeling like we are not ready yet to handle questions on wills. In the next class, we shall also look at further questions on wills. Also, there are usually question ones. Question ones are usually on wills. So we will discuss another question one in the next class, so that you understand how wills are supposed to be done. Tested succession, making of wills, valid wills, and everything else, including the gifts, nominations, and survivorships. So we talk about that in the next class again, as we also get into intestacy. So please take your time to go and read again on wills. I don't think we are ready yet to handle all questions on will, but we should be after one or two papers. That is, we should be after one or two papers. Are you guys together? Okay. Okay then. So if there's no question, stop recording. I will share the recording once it is ready. Again, you know what to do, guys. Please ask for